for 15 or 20 minutes and then open it up to questions. So is everyone situated and everything? We're good to go? All right. I like to start things off by asking a question. Why are we even here in the first place? And so I don't know about you guys, but I think a lot of people, when they hear about estate planning and stuff, they know they want to get around to doing it, put it off sometimes. But ultimately, we want to get our stuff together, like get our ducks in a row, get our affairs in order, so that we don't end up being that guy who's just, or gal, who's just going through life without a plan and just, oh, stuff happened. Oh crap. Now I need to like scramble to clean up a mess. Like for me, my law firm's called Generations Trust and Estate Planning, but I actually really try to help people just not leave a mess for their immediate loved ones. Like if I get in a car crash on the way home tonight, I don't want my wife Anna to like have to go to court to prove that I want my stuff to go to her. That's what I really do. And the reason I do it is because when I was 16, my dad and mom were going through a divorce. And for some reason, my dad, who is an educated medical doctor, ended up throughout the divorce proceedings transferring a bunch of assets to his girlfriend at the time, putting them in her name. And then he died. He literally went to work. There was a traumatic event and he died. So all of his stuff ended up going to his partner when he had 5 kids at home. That is not an adult decision. That was absolute garbage. And I love the guy, but I mean, it really like hits home that I'm not talking about fancy estate planning where you have all these complicated trusts and stuff. I'm talking about getting some proper adult decisions on paper so that we're not leaving a mess for our direct loved ones. So anyway, that's my long-winded problem. Get our stuff in order. The solution is just getting knowledge like this so you guys can make informed decisions about what your options are, what you maybe should do, what you should be looking at, going through the due diligence process and figuring that stuff out so that you guys can make an informed decision. So with all that being said, I think there's a ton of confusion about what estate planning is in the first place. So I wanted to boil this stuff down into like a handful of words, which I hope you guys will go on this little definition journey with me. So who here has an estate like right now? An estate. You got an estate. Hell yeah. Yeah, you got an estate. All right. An estate, like a 14-year-old middle school kid has an estate. An estate is just your body plus your stuff. Everyone has an estate. Okay. So we all have a body. We all have stuff, even if it's like a 91 Honda Accord. But what is an estate plan? Then what's an estate plan? All that is instructions for your physical body and your stuff. What the heck do you want to have happen to your body? And what do you want to have happen to your stuff? And it's not necessarily about dying. It's like, I had a call today, an hour call with a client, and he was in a domestic violence situation where his girlfriend tried to strangle him. Now there's a legal proceeding. That caused him to call me and be like, man, I need to get my stuff in order. Like this was just an event that happened. So anyway, it's instructions for your body and instructions for your stuff. So who the heck cares about an estate plan? You should only care if you think it's possible that A, something unplanned may happen in your life, or B, that you may eventually die at some point in the future. Other than that, You literally don't give it a crap about an estate plan. Who cares? Only if those things are possible. And I will tell you this, it's super important to know that you're guaranteed to either use your own plan, those are your own instructions about your body and your own instructions about your stuff, or you will use California's plan or whatever state you're in when stuff goes sideways. So you use your own plan or California's plan. So what is California's plan? California's plan is called probate court. And some of you have probably heard about it, maybe some not. But the probate court, there's a probate code that's thousands of pages that are the state instituted rules for what should happen to someone's body, what should happen to someone's, if they're mentally incapacitated, can't make decisions for themselves, what happens to property when it's owned by siblings, one sibling passes away, does it go to the sibling or does it go to the person's husband, does it go to the kids? There are rules for that, and if you don't make rules of your own, you will be subject to California probate court. And just as a small example, because we're talking real estate, we're in a real estate office, to probate a house. If someone owns a house worth $1 million and they pass away, that house goes to probate. In order to figure out who gets the house, who's responsible for the house, who can sell it, who gets the proceeds from the sale, that'll take a year to a year and a half, and it'll cost $25,000 between lawyers' fees, court costs, all that stuff, to probate a $1 million house, which there's a lot of houses in Long Beach that are $1 million. And that's gross value of the estate, not net of a mortgage. It's like if your house is worth $1 million, it's 25. It'll end up being $25,000 in a year and a half of your life, which really sucks. And so I'm sure some people have had experience with that kind of stuff. But anyway, the bottom line is, so if we take that probate is a nasty, traumatic court case about your stuff, that part sucks. But also the fact that your direct immediate family now has to go to court, that is even worse. That the fact that, the costs, the year and a half, the fighting between family members, that sucks. But your direct loved ones will have to go to court, and that would leave a really bad taste in people's mouths. So I try to help people avoid that. One of my favorite ways to avoid that is by creating what's called a living trust. And a living trust, that's the next definition on the little thing there. The living trust is basically a bucket that you put your stuff in. So your house, you put that in. Bank accounts, put that in. Investment accounts, put that stuff in. We assign things like your automobiles, jewelry, household furnishings, all that stuff into the bucket. And then we have a nice set of instructions in the bucket that says, what do I want to have happen to this stuff if A, I am mentally incapacitated, like I get in a car accident, or I have like an aneurysm. Like I had a buddy who's 35 that had like a weird freak health thing. He's okay now, but during that period of time, you have to have instructions for your stuff. It's not just after death. So it's anyway, the living trust is a bucket with a set of instructions. What do you want to have happen to your stuff? Who should it go to? Who should manage it? And then that's during your life, and then after death too. The living trust is a probate avoider arrangement. That's the biggest thing that I hope I drive home. Or maybe the next one is the biggest one. Anyway, some people think that having a will, last will and testament, you guys see in the movies and all that, my last will and testament. In California, that will straight to probate, and you're in probate. So you have a will, even if you've named your wife as the personal representative, or your firstborn son who's a financial planner as your personal representative, that son now has to go to a probate judge and say, hey, judge, Pops just died. Here's the death certificate. He named me my personal representative. Will you please bless this will? And then you go through the probate process, which is something that most people, when they know about it, want to avoid. The will is your wishes after death. It does not avoid probate. The will in California does not avoid probate. And then the last definition, people talk about powers of attorney. What is a power of attorney? An advanced healthcare directive. What the hell are these things? It's just simply giving someone the power to act in your shoes if you are unable to do so. So it's like if I was in a car crash or if I was in the hospital and a mortgage was in my name and my wife's my power of attorney, then she can happily pay the property taxes and the mortgage payments, and banks will deal with her, and hospitals will deal with her, etc. So those are the definitions that I hope, at least in my humble opinion, I think everyone should kind of know. And there's so many, like if you look this stuff up, it's just paragraphs of like just really long words and legalese, and it's just, I find it annoying because an estate plan is not just for like rich people with $20 million. That's for damn sure. All right, and I'm going to open it up to questions. I'll talk for like 5 more minutes and then I'll open it up to questions, and we can go as long as you guys want on that. Common mistakes and how to avoid them. Well, when you wait until a health or a life event forces action on you, now you're scrambling to get your stuff together. Like, does everybody in this room probably have seen that in some form or another? Maybe, I would assume. Like literally everyone I talk to, there's nobody that's like, oh yeah, everything's been peachy and like, you know, life's just chill. It's crazy. Like my dad passed away. Grandma passed away in the state of Maryland, then reimbursed itself for her long-term care against her house. My sister had breast cancer. My stepdad had 2 brain surgeries in the last 2 years. Like everybody knows someone who's gone through some stuff. So you wait until a health or a life event to take any sort of action, you find yourself scrambling and mistakes get made, and it's oftentimes ugly. So the best way to avoid that kind of stuff is just have a conversation with your loved ones, have a conversation with a free resource like me or any other like people that know about this kind of stuff, and see what your options are. Get educated so you can make an informed decision. Common mistake, we're talking about real estate. People come to me a lot and they say, I want to add my son to my property so that will avoid probate. And because if you hold property as joint tenants, if one joint tenant dies, that the deceased joint tenant stuff just vests in the remaining joint tenant. So that is true that there are ways to hold title to property that will avoid probate, which is true. But what that person doesn't realize is, number one, once mom passes away, there's a tax mechanism called a step up in basis. And if the original joint tenant passes away, you only get 50% step up in basis. So ultimately, when that son goes to sell or pass it on to his kids, you're looking at a massive capital gains hit. Whereas if you give the son the property in a living trust, you get full step up in basis at the date of death. So it's a tax time bomb to simply add people as joint tenants. You have to look at like, is probate avoidance my only thing, or do I also care about taxes? The other thing about adding joint tenants willy-nilly is if mom adds son as joint tenant and then mom's like, I need to downsize and go live in a like long-term care situation, I want to sell the house and finance my retirement or my whatever, she now needs the other joint tenant's permission to sell the house. But do you know what I mean? Like, you're adding someone to title who's just as much as of a decision maker as you. it's not super smart in most of the times. So beware. All right. I see this all the time too, especially in real estate transactions. Husbands and wives taking title as joint tenants, just funky vesting, taking title, because oftentimes in real estate transactions, I think, at least from what I've seen in the years, is like everyone get like purchase price is this, buyers, all right, we release contingencies, great. All right, now we're sending out escrow packages and loan documents with the travel notary. The notary shows up and is like, how do you want to take title? And then the husband and wife are like, I don't know, what does everyone else do? And then it's like, oh, they end up taking title as joint tenants, which is not the worst thing ever, but they should be taking title either in their living trust if they have it, or as community property with right of survivorship. That's CPWRS. That's the proper way for a husband and wife to take title to real estate, if not in their living trust. It's just so, anyway, take title properly. What's that?
Can you repeat what is CPWR?
Yeah, it's community property with right of survivorship. Community property with right of survivorship. California is a community property state. The presumption is that when a married person acquires property, any property, not just real estate, it's presumed to be community property. Community property is a special type of like characterization of property. It means it belongs to the husband and wife jointly. And it's just better. It's just not sloppy, I should say, if husband and wife take title appropriately, or, as the case may be. There's other ways to take title too, but in the married situation, husband and wife, first-time home buyers buying a house, do it in your living trust or as community property with right of survivorship. All right, something else that happens all the time, people put a property into a living trust or an investment property in an LLC, and then they do not add, they don't tell their insurance person, hey, we put the property title into an LLC or into a living trust, and they don't add the trust or the LLC as an additional insured on the policy. And that is just a way for the insurance company to deny a claim. It's just, you got to do it. Like, if you transfer title, you got to make sure that your insurance is covering the new title holder. Super important. Oftentimes just completely overlooked. All right, so speaking of putting investment properties in LLCs, you guys, I'm sure some of you guys are interested in that, and we have some real estate professionals in the house, and it oftentimes does make sense to put an investment property in an LLC, subject to what your goals are. But the first line of defense, at least as I see it, is really good insurance. That's step one. And then if you do decide, hey, I'm going to create like a proper site, I want to treat my my rental income as a proper business on the side, form an LLC, put the property in the LLC. That's great. Tell the insurance company that your LLC is the new owner, add it as additional insured. And please don't transfer to the LLC until you contact your loan company and be like, hey, I'm transferring this property into the LLC. Is that okay with you, Mrs. Lender? Because if you do that without lender's permission, although I haven't seen it done, if you do that, you may be violating the terms of your loan, and they may call the loan due. And it would be an evil thing to do, but I don't know. I just would hate to see that happen. But most lenders will be like, yeah, sure, put it in your LLC. We just need to make sure that you're the true owner. You're still the guarantor. I hope this is making, I know I'm talking a lot, but check with your lender before you put a rental property in an LLC. That is important. The next thing that people, I hope this is good info for you guys. Some people will create an LLC and they'll put the property in it, but then they don't respect it as a separate company from itself or from you. They don't actually treat the LLC like an actual business. So they're having rents paid into their personal accounts. They like use LLC income as their personal piggy bank. They run personal expenses through the LLC. And that, my friends, completely negates the point of having an LLC in the first place. The point of the LLC in the first place is to limit your personal liability, which means if I, Camden, own an LLC that owns a rental property and my tenant sues the property owner, they're suing the LLC. And so that the recovery to that tenant is limited to what the LLC owns. If I have used that LLC as my personal piggy bank, it would take 2 seconds for a good litigation attorney to be like, that's just Camden's alter ego. Of course, we're going after him personally. That's not a real business. That's bullshit. So if you don't treat the LLC like an actual company, you will negate the limited liability aspect of having created it in the first place. Taxation, LLC taxation is a whole nother thing. If you guys want to get into it, we can. But LLCs, depending on who the members are and stuff, can be treated as pass-through entities. You can have them taxed as an S corp. You can have them taxed as partnerships, and those are important things to figure out what you want to do. If it's taxed as a partnership, it'll file its own returns, and you as a member of the LLC will receive K1 income. If you have it taxed as a pass-through entity, you'll report income on your personal returns on a Schedule E, or I think it's E. You just got to know about this stuff before you willy-nilly put real estate into an LLC. I'm sorry, it hits close to home because I see it all the time. All right, tips and ideas. Yes.
The way that you decide how you're going to tax the LLC, does that affect how much open you are to personal liability? Meaning, like, if you do the pass-through taxation, would someone say, well, they're doing the pass-through taxation, well, that's probably their piggy bank, or not really?
Not really. As long as the integrity of the company is maintained, you should have a personal liability shield. A multi-member LLC that's taxed as a partnership might have more of a shield. But a single member LLC that's a pass-through entity should limit your personal liability if it's done proper, right? But they do say that a multi-member LLC provides more protection. Yes?
What would be some good examples of what could be considered an investment property?
Yeah. A good example of an investment property is I own, I guess, if you have a second home that generates income, or even if you have one home and, well, you don't want to put your personal residence in an LLC, that's for sure. So it would have to be a second, anything over one piece of real estate that's generating income for you. You can create an LLC, just like your lease agreements should be in the name of the LLC, property management should be dealing with the LLC, bank account in the LLC name, employer identification number. But yeah, it would be like I own a single family residence in Bixby Knolls and I have a duplex in Belmont Heights. I want to put the Belmont Heights, one of the units is short-term rentals and Airbnbs, and then the other unit is a long-term tenant with a 1-year lease. So that would be a good example of like a business, like a proper side real estate income business. If you need more, I could probably think of them. But just
I'm in the salon, I'm a hairdresser.
Okay.
So, in California, we rent.
Gotcha.
Stations, or they don't really like commission anymore. So
right.
Could a salon per se be an idea for an investment?
If you owned it, yes.
But a lot of times they do lease.
Okay. So yeah, you probably wouldn't, if you are leasing, you wouldn't be able to transfer that leasehold interest into an LLC. You would want to own it and then put it in the LLC. Yep. Okay, tips and ideas, and then we'll open it up to questions. If you don't go with the living trust, you don't want to get around to doing your planning, that's fine. I get it. Like some people just they literally will wait till they're 80 and they have a health event. I get that. But in the time that we have right now, what you can do is go to your Chase bank account, and you can be like, hey, I own this account in my personal name. I want to add my significant other on the title of that account, and I want to add my son and daughter as transfer on death beneficiaries of that account. So most anything from like 401k plans to bank accounts, investment accounts that are open with brokerages, stuff like that, you can name payable on death, that's POD, or transfer on death, TOD, beneficiaries. If you just do that, it'll save you a lot of stuff with cash accounts and retirement accounts. So that's something that you can do tomorrow for free. I highly recommend you do that. Oh yeah, legacy contacts to devices. A lot of people don't know this, but like if you use password managers and you have like 120 passwords, you want to make sure that your significant others can get into your devices. And so give them the passwords. And also you can just do it in the settings on the iPhone, add legacy contact to basically my cloud data. And that way, if God forbid something happened to, you, the person that you nominate, Apple will deal with you with respect to getting their data. And sometimes that could be helpful to like figure out what the hell happened, or maybe there's some financial information relevant to the estate, stuff like that. Yeah, I put some of this stuff in here thinking that some real estate people might be of interest, but oftentimes I see real estate professionals that are making over 100 grand a year, they don't have an entity set up. So if you're doing real estate, you're making over 100, like 75 grand and up, think about having an S corp and running it as a proper business. This is because with an S corp, you can basically pay yourself a salary, which is taxed at full freight. And then anything else is dividend, you can take as dividends. That's not subject to a 15% self-employment tax, which is Social Security and Medicare. I think it is. It's like 15%. So if you made 100 grand this year, pay yourself a salary of 75 grand. It has to be a reasonable salary. The rest of that 25,000 is you're saving 15% on 25 grand. That's something that, you guys should be thinking about. And then anyone that has a business and has kids, you can, I'm not trying to give you tax advice. I'm just saying bring it up with your CPA, because you can technically have kids on payroll if they do something, like for example, in real estate photos, if your kids posed for you in your real estate photos and it's a legitimate business activity, you can basically shift, I think it's 13 grand in income from your business to your kid, and they can have that in a custodial investment account or a custodial retirement account, and you're paying, it's subject to 0% tax, whereas maybe your business is being taxed at 30%. So if you shift 13 grand to your kid, it has to be for like legit work. Maybe you have a teenager who cleans up around here, or stuff like that. You can shift 13 grand over and they will be paying 0%. That's like a $4,000 little thing. And there are very complicated rules about this. So I'm not trying to advocate for it, or I'm just saying talk about it with your tax professional, because it could be a great way to save for a kid's college and stuff like that. That's all I have to say. I'll open it up to questions. Do you guys have any questions? Yes.
should you have your own LLC for each investment property, or just one LLC for multiple investment properties?
It's a good question. I look at it from multiple angles. You got to have different frames looking at this type of thing. Number one, how much equity do you have in these properties? If you have a lot of equity, it makes more sense to firewall each of them. If they're like, you're talking about a $2.5 million apartment building with a decent amount of equity, that should probably have its own LLC. If you're talking about two $700,000 single family residences with nice tenants in there, but they're highly levered and you have like $100,000 in equity in each, you could probably get away with putting both of them into one. Comes down to your risk tolerance, how much the property is worth, like fair market value, how much equity you have in it. And also I look at it from a geographical location. So obviously if you have some out of state real estate, you can probably bundle some of them up by geography. Like if, again, you know, the possibilities are endless, but value, fair market value, equity, geographic location, and your own risk tolerance. Because at the end of the day, LLCs cost money to set up, and they have a minimum $800 each year. So, but you know, the more firewalled they are, the more limited of a recovery someone who's against you has. But I hope that helps. Yeah. Anybody?
I have a question.
Yes.
I have a trust.
Uh-huh.
And I need to make an addendum to it.
Uh-huh.
Can I do it and have it notarized, or
Yes.
will it still be legal?
Yeah.
Okay.
Yeah. Just don't mess up. No, I'm serious. Like if it's a super easy thing, just like Google California Living Trust Amendment, try to find a nice form because you need to recite what it is that you're amending. It needs to reference the actual code or the actual section that you're amending. It should have some formalities in it, but yeah, you can do it and get it notarized, but just make sure it's done right. Yeah. I'm not being facetious. You can do it yourself. Yeah. Yeah.
Well, what I did, I had a house and I sold it, and then I moved into a retirement community.
Okay.
And I didn't put that place into my trust.
Okay.
And that's
Why
what
not?
I want to do, and just leave it, I guess, do a TOD to my children.
Okay.
So that's all I want to do.
I'm sorry. Okay. I'm not, I think we're talking two different things here. Why wouldn't you put, okay, TOD and putting it in a trust is two different things. Okay. So why not put the retirement thing into your trust and leave it to your kids?
That's what I want to do.
Oh, okay. So you don't need to amend your trust. You just need to put the real estate into your trust.
Okay.
Do your beneficiary designations, meaning I have already previously said in my last trust that I want my stuff to go 50-50 to son and daughter. Is that still true?
Yes.
Okay, then you just probably put the real estate into the trust, because whatever's in the trust will follow the terms of the trust. That's the beauty. You could, like 10 years from now, sell that place, buy a new one, put that one in your trust. You still didn't need to modify the trust. You don't need to amend it. You need to put the real estate in the trust, and then on the back of your trust, there's something called the Schedule A. You need to write the real estate assessor's parcel number, address on the Schedule A. Yeah. I'm not giving legal advice. I'm just saying like what I would do if I were you. Okay. But you should reach out to a title company or an escrow company or a real estate contact and be like, hey, help me write the deed. You need the full legal description. Just don't.
I guess that's the problem.
Okay.
There's no deed.
Okay.
I live in Leisure World, and there's shares.
Yeah.
So I don't know.
All right.
So maybe I do need an attorney.
I mean, I know those can be transferred into trusts. You just got to pull up title and see. So do you know we can talk. I'll pull up title. I'll see if I can help you. And if it's literally just like a deed, I can help you. It's fine.
It's not a deed,
If it's a share,
it's share.
if it's a share, that's what I meant.
Stipulate, no, it's not a deed, it's a share, so.
As long as there's no,
Make sure that only-
It's a mutual association.
right. So how did those go into the trust?
You don't own any property.
Okay.
Well, you own it, but you don't own it.
Yeah.
You know, it's kind of,
And you
when
own a
something
share,
happens
you
to
own a
it.
share of leases.
Oh, interesting. So yeah, maybe there's a restriction on transfer. I don't know. How do you pass it to your loved ones?
No, that's the problem. That's why I want to find out, because I've heard there's problems where, you know, people, family members have lost it, and I don't want that to happen to my kids.
That makes sense. Yeah, makes
I think
sense.
they own the building.
Yeah.
Because they do upkeep and maintenance even on your internal in the house. Like if the water heater goes out, they replace it.
Sounds like a good gig.
Well, it's a,
I'm sure we can find out the answer very quickly. That's all I'm saying. If you want to just even leave me your email, I'll follow up with you. Just write it and yeah,
okay.
cool. All right.
Okay, I have a question.
Yes.
How often should you look at your living trust and update it?
You should probably look at it like every 3 years. Some people like to just make it and never look at it again. But if no life event or no change, nothing is different from 5 years ago, then you're probably fine. But if someone has died, the person you've named as successor trustee is like not in good health, you want to make those amendments as you go. But I recommend people look at it every 3 to 5 years, because I like to think of this as like an active living plan, not just like, oh, I paid someone a couple grand to make me a trust 3 decades ago, and then it just, I don't know, stuff goes sideways.
It's up to the person that has the living trust to do it, not the attorney that holds it, right?
Yeah, totally. Yeah. Unless you're on some sort of contract or a plan with the attorney that, yes, it's on you. Definitely.
Experience with my parents' living
Yeah.
trust because it was bad.
Gotcha. Yeah. Makes sense.
What process do you follow, or do you do anything as far as a recommendation of contingent trustees?
Yeah.
Are there any recommendations that you have for that?
Oh yeah, totally. So I think the trustee selection is super important. So what a trustee is say I, Camden, want to make a living trust, like a straightforward living trust. So I make the agreement with myself and I say, all right, now Camden is the trustee of the Camden Trust. Now I say, if I pass away, we need to nominate someone else to step into my shoes, because now they are effectively the owner of what's in my trust. So I look at it from the perspective of, if you're married, I like, usually my clients want to have especially if it's first marriage. If it's like second, third marriage, stuff gets funky. But the successor is competent and has your best interest in mind. Those are my real, if I had to boil everything down, core requirements, because the way I like to write trusts is basically the trustee has the ability and is empowered to consult with other experts. They have the ability to hire tax people. They're given a lot of powers, and I like to make it clear, I don't expect the trustee to have to quit their day job just to administer like some mess. So I want to ease as much of the burden as possible. So I would say anyone competent who has your best interest in mind. Other than that, I like to follow, who are my most trusted people. But that's the process I would use. Are they competent? Do they have your best interest in mind? And are they likely to survive you? Are they likely to outlive you? And I like to, spouses are great. And usually spouses are co-trustees anyway, but do you have any thoughts on that?
Well, I just often consult with my clients and say, when you look around the room, as far as your family is concerned, who's going to, act in the best interest of the
Right.
period?
Yep.
Because unfortunately, that selection process can also lead to some that situation.
Yes, 100%. Yeah, I couldn't agree more. And I really like them to be like highly competent. That's another thing. It's like because then they'll know that they don't want to have to do it all, because it can be very taxing, or very, I shouldn't even use that. It can be very complicated and take a long time. So anyway, any other questions? Yes.
Yeah, I wanted to open a living trust. I was talking to that because I don't have any family here.
Mhm.
I have two properties and business.
Mm-hmm.
The business is an S corp.
Mhm.
But they said I wouldn't be able to appoint my sister to be the head or to basically get everything because she doesn't. Is that true? Or like,
She can be a beneficiary. She can get everything.
even if she's not American?
Yes. But what people have the IRS basically has a problem with non-US citizens being trustees. But yeah, I don't think there's anything wrong with a foreign or a non-US citizen beneficiary, as long as the trust is properly structured, in that if you were to ever owe estate taxes, which is a very high bar right now, the IRS needs to be assured that they would be paid before your sister gets her payout. But there's I think it's called a Q dot. It's like a qualified I forget. But yes, there's ways to get around it to leave your stuff to your sister for sure. Yeah. Good question. I'm not sure if I 100% know the answer to that, but I would be very surprised, because people that are non-US citizens do inherit. The trust will require extra protections for the tax man. Mm-hmm. Anybody else? I know this is like really fun topic, but
How much is it to open the trust?
yeah, my basic plans for couples are about $3,000 for simple and $2,500 for individuals. And what that is usually like a living trust, wills, powers of attorney for finances and healthcare, real estate stuff. If you have any business stuff, we transfer that in. And then there's a bunch of ancillary documents, but the core documents are about $3,000. If it's simple, I have to qualify that. Yeah. Anything else, you guys? Yes. I it's hard to say, because it honestly takes me the same amount of time to review someone else's work, point out mistakes. You should fix this. A lot of people come to me, they're like, I need to just simply change one thing. And I'm like, okay, I can help you with that. And then we find 8 things. But if it's a small change and your estate is not complicated, it's not expensive, like it may be a couple, like, I don't know. It depends what you think expensive is. But like, I do my normal quote for people that have a whole estate plan already and they want to make a simple modification is $1,500. But I don't want to quote you on that, because if we get on the phone and you're like, I literally just need to make this one thing. My trust is 10 pages long. I don't have any rogue family members. I'm not married. I don't, it depends how like complicated we're talking here.
Do you include
Yes.
amendments on your trust that you do?
I'm sorry?
Do you include amendments at all?
Yeah, I do. For the first year, the first 12 months after I draft, it's just unlimited whatever you want. And then I haven't really come up with like an ongoing maintenance plan. I just usually say, like, clients work with me over years. And just tonight, like several texts from clients that are like, hey, what's up with the like Corporate Transparency Act thing coming up early next year, where we have to do beneficial ownership statements and stuff. I don't charge people for consults and one-offs, but I include everything in the first year.
It's like our kids are minors right now, so
Right.
basically we're going to need amendments when
Yeah, yeah.
Become majority.
Yeah, I get you. It's the stuff that I've done is much easier to dig into and be like, okay, cool. Yeah, that's a 1-page amendment. You're just modifying, a couple sections, adding the kids as successor trustees or something like that. But stuff that I'm looking at with brand new eyes, it's like now I'm signing off on someone else's work. So now I got to go through it with the fine tooth comb. But I always tell people, I had a client literally reach out this week. The guy's worth $18 million. And he reached out and is like recently diagnosed with bone cancer. And they've given him 2 months to live. So him, his daughter, and financial planner reached out to me. They're like, Camden, we got to do these like last minute changes to this complicated trust. A dynasty trust, living trust, 3 LLCs which own substantial apartment buildings. I'm like, you guys, you got to go back to the original drafting attorney because you'll probably save 15 grand. Like if I have to come in on a rush, last minute, all like death implications, tax implications, like I have to charge obscene amounts of money to even want to touch that. So I just got a call. I got a call from them like 2 hours ago. They're like, thank you. We talked to the original drafting attorney. They're going to handle it, blah, blah, blah. It's like, I will happily try to point you in the right direction for what's best for your situation. I was talking to you back there. I know, I don't, yeah, I'm happy to review trusts, but sometimes it's better to work with your original attorney. But if they suck and they're not responsive and nice, come on down. We could even just have a free call and I can tell you how much it'll cost, but it's hard to say right off the bat. Yeah. Yes.
It's not to my intention that something, and I don't know what particularly, to be in your trust that protects, I have 2 sons, to protect them so that the in-laws don't take or their wives don't take something from them that has been specifically given to them.
Yeah. So the way it works is if someone gets an inheritance, that is presumed to be their sole and separate property, even if they're married. Okay? Even in California. But what people mess up all the time is like, oh, sweet, let's put this 750 grand into the joint account. They commingle that. That's like instantly now super questionable whether that was meant to be sole and separate property or if that's now community property. So the way we do it is basically there's a couple of safeguards. One, you have the sole and separate property schedule on the back of the trust that says this asset is supposed to retain the sole and separate property of son. Okay. Then you have in the trust something that says if in the case of divorce of, son to spouse, she will have been deemed to predecease the gift. It's just special, it's just language in the trust that basically says if they ever get divorced, she's dead to us. I mean, seriously, it says that we say it like we will treat her as having predeceased the gift. So there's ways you just got to be really clear with your kids. Like you got to open a separate account. Don't use it to pay the joint mortgage. You can use it have it invested for the kids or something like that, but don't be using it as like the marital piggy bank because later down the road, if stuff goes sideways in the marriage, it's just going to be a mess. So, and they should, if they're getting an inheritance, you should encourage them to get their own estate plan. I create separate property trusts all the time for people, even married people. It's like this house was inherited by my mom. I inherited this from my mom. I'm going to have a Bobby separate property trust, and I'm going to have a Bobby and Linda joint trust. It's not uncommon to have multiple trusts. I know it sounds fancy. It's not, though. It's just meant to hold the various things depending on the situation. All right. Anything else, you guys? And anybody, hey, grab a card and give me a little email, little call. Oh, I should. Yeah, let me snag one of those. Don't forget to ask me. Yeah. All right. Yeah, so I've got a little, if anyone wants a free call, you can sign up here. I have some hours picked out, but you can also request below. Also on the bottom of your handout, that is my email address and my business cell phone. And if you go to, it's easy to get on my calendar. I just have time slotted out for discovery calls. So no strings attached. I just talk to you about your situation. If I can help, great. If not, I can put you in touch with who can. And I literally I encourage people to go about doing their planning properly, and will help in any way I can with that.
Where's your office located?
In Seal Beach, close to Leisure World. Yeah, on Main Street. Yeah.
Okay. That's all the better.
Yeah. Yeah. But I live here in Bixby. I also have a home office too. So I'm like, I'd say 80% of the time at the Seal Beach office, 20% of the time up in Bixby. And like, I have meetings up on Atlantic at the Bixby Executive Center or Bixby Business Building, the glass one.
Is that on San Antonio?
Yeah, San Antonio and Atlantic. Yeah. 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 Well, thank you guys so much. And thanks, Ann. I want to thank Ann and the team. Dude, what a great spread. Thanks.